Welcome to Freedom Worldwide. I'm Tom Palmer, and it's my privilege to work with Atlas Network. It's a network of 569 independent organizations in 104 countries. About a quarter of those partners are in the United States. And today you'll get to meet some really awesome lawyers who've had a string of very important successes in United States courts that vindicate individual rights and secure those rights through effective, constitutionally limited, and legally authorized government. Our guests today are Stephen Anderson, who's the president of Pacific Legal Foundation, Christina Martin, and Anastasia Boden. They're three power lawyers from Pacific Legal Foundation. This Atlas network is really amazing. They have put an end to the practice of what is called home equity theft by taxing authorities. You'll hear a lot about that in a moment. And they've also done some very important work addressing the so-called Chevron deference. So Christina, why don't you start us off by telling us what happened in the case of Tyler versus Hennepin County, and also how you achieved that really significant victory.
Sure. So in Tyler, our client, Geraldine Tyler, who is now 95 years old, underpaid her property taxes. She had moved out of her home, moved into a senior living community, stopped paying the taxes on her Minneapolis condo. She owed about $2,300 in property taxes. The county tacked on almost $13,000 in penalties, interest, and fees. But rather than just collect the $15,000 that it was owed, the county took her entire condo, sold it at auction for $40,000, and then kept all the money. That's something we call home equity theft. And the US Supreme Court held that when the government takes more than what's owed, it's unconstitutional and violates the takings clause in the Fifth Amendment. The Supreme Court explained that a taxpayer must render unto Caesar what is Caesar's, but no more. And this is a really big victory because, as it turns out, Minnesota is not the only state that's been taking more than what it's owed from people. There were more than a dozen states when we got our petition granted by the U.S. Supreme Court. And we actually first began work on this issue back in about 2015, maybe 2014, when we learned about a case in Washington, D.C. Involving a man named Benjamin Coleman. He had dementia, failed to pay a couple $100 in property taxes, and lost his $200,000 home as a result. And we filed an amicus brief. That case ended up settling, but next thing you know, we started getting calls from Michigan, and we got a client who lost his entire house over $8. We got a Michigan Supreme Court victory out of that. And in about 2020, we started strategically taking on this issue. We started filing lawsuits in a number of these bad states, working on legislative efforts. And so we got something called a federal circuit court split. If you can get multiple federal courts that disagree about something, then the U.S. Supreme Court is more likely to take up that issue. And that's exactly what happened. The Supreme Court granted review, and last year held that it's unconstitutional.
Well, one thing I've learned in studying your successes and the work of other similar public interest law firms is these are never really just one-off victories. Most of us in the public think, yay, we won at the Supreme Court, it's over, the injustice will cease. But it turns out there's a lot of really patient work to be done afterwards to ensure that state laws respect the legal rights that you've indicated in court, model legislation is prepared to forestall abuses in the future, and also that the past injustices can be rectified to the extent possible. Now, Pacific Legal Foundation was awarded a grant by Atlas Network to ensure that those rights that you secured in the home equity case are actually respected in every jurisdiction. How's that going right now?
It's going well. We actually had two big wins in the Nebraska Supreme Court last week, in a couple of cases that we had also petitioned the U.S. Supreme Court. And after we won Tyler, these cases got sent back to the Nebraska Supreme Court. And last week, the court held that what's going on when the government takes more than what's owed is also unconstitutional in Nebraska, even though the government gives the windfall away to private investors there, unlike Minnesota. Now, I use the present tense, but actually we got the law fixed with the help of an SPN group, an Atlas partner, the Platt Institute last year. But that doesn't remedy what happened to our clients who lost their property before the law was fixed. We also have had a number of policy wins in states around the country. Just to give you a visual of what I'm talking about, I want to show you what the map looked like back in 2015 when we first really started to take a look at this issue. As you can see, there's a lot of red on this map, and those red states were states where the government was taking more than what was owed regularly. That was the normal way to collect taxes. You owe the government $8, we take your whole house. The yellow states had loopholes on the books, and some of those states we know for sure were using those loopholes. States like Ohio were engaging in this practice pretty regularly with their loopholes, where they don't normally take it, but if they want the property for a land bank, they'll take the whole house. And this is what things look like now. You'll see a lot of green and a lot less yellow. Again, some of these yellow states, we don't know if they're actually using it, but this is the updated map. And one of the things you'll notice on here is we've got some stripes, and those striped states are states that have technically fixed their rules, but they've created a claim process for people like Miss Geraldine Tyler to claim their money, but they've got such a short time period, or there's other obstacles to claiming your money, that we believe that that also is constitutionally suspect. There would be a lot more striped states on here, except that we have been sending policy people out around the country. We've been working with coalition partners, and we've stopped some of those attempts to make it hard for people to collect their own money, and states like Minnesota. And so things are going well. There's still work to be done, as you can see, but we are looking forward to the year ahead.
You know, I encourage people to go to your website and learn more about these cases, because when you learn the details, they're really chilling, with tax assessors and government officials sending back emails about what they're going to do with someone's home now that they have it, or whether they'll have a garden party there or a barbecue and so on. Really very powerful illustration of the abuse of state power. And what you've achieved is a fundamental win for civil rights, a vindication of the rights of members of a civil society that has for too long been considered non-fundamental or incidental, of lesser importance than other civil rights. But PLF has done so much work to secure our rights, but I think most people don't understand, what does a public interest law firm do? How are you organized? How are you structured? And so, Stephen, you're a lawyer. You're also the president and CEO of Pacific Legal Foundation. You've worked with other groups in the past. So a simple question: what's a public interest law firm?
Well, the simple answer is it's a law firm that works in the public interest, obviously. But there's more to that. There are multiple theories of social change, and the one we engage in is using the judiciary to move society towards a freer position. And it's a very similar kind of tactic that we saw groups like the ACLU and the NAACP back when they were brand new using. One of the great things about the structure of our government is we have three co-equal branches. But for a long time, particularly post New Deal, you saw the judiciary kind of shrink in its power and its belief in its ability to overturn what is unconstitutional. Fortunately, though, there are groups like Pacific Legal Foundation that take the government to task and do that through the courts. Now, as I said, that's one way of doing it. There's also using the legislative branch or the executive branch. But what we have seen is sometimes the most durable changes occur through the court system. And we know this because some of the laws that we are still fighting, are a century old, or some of the cases that we're searching to overturn are that old. So we know that when we achieve a victory like we have in Tyler and some of our 17 other wins at the United States Supreme Court, that those are going to last a long time. I mean, what we do is what we consider to be pretty significant and sophisticated constitutional law. But at the end of the day, it's a very simple equation. What we're looking for is sympathetic clients like Miss Tyler. Evil villains, well, that's not hard to find given it's the government. and outrageous facts. And you put those things together, and it gives judges a reason to rule in your favor, because often what we're trying to do is overturn a centuries-old precedent, or sometimes decades-old precedent, or to push the boundaries beyond wins that we've had before. One of the great things about Pacific Legal Foundation is we've now been around for 51 years, and we've been able to extend and entrench some of the wins that we've had at the Supreme Court. So we'll take a little bit of territory and then take a little bit more with our next Supreme Court case. So all of our cases are designed to kind of advance the ball incrementally over time, knowing that the kind of arc that we're dealing with is a very long one. We truly believe that the price of liberty is eternal vigilance, and understand that we're going to have to consistently bring cases forward for courts to hear.
You know, I'd like to remind our viewers that you can pose questions in the chat box, as we're going to be dealing with a couple of little bit complicated legal doctrines, and I'm sure that our guests can explain them very clearly. One of the really impressive things about what the Pacific Legal Foundation has been doing is your willingness to work with so many other groups, among them a number of other Atlas Network partners. The Platt Institute in Nebraska was mentioned by Christina, the Buckeye Institute in Ohio, Cato Institute, Institute for Justice, and others. And you've really demonstrated the power of a network working together, can coordinate, share research, take on particular bits of a project, and then change the world for the better. And I would also like to point out for our audience that you can be a part of this effort by financially supporting this network. Via Atlas Network, we help our partners with training, networking, and investments in their projects. There's a link in the chat box, or you can just visit www.atlasnetwork.org/donate to become a part of that effort. And with $25 minimum donation, you'll get our magazine, Freedom's Champion, delivered to your door by a uniformed agent of the federal government. I mean, what more can you ask? Well, I'd like to turn, though, to one of the other remarkable sets of cases, a little bit harder to describe, the cases that are involving so-called Chevron deference. It puts a thumb on the scales of executive branch agencies in cases of legal disputes about the imposition of regulatory policies and costly compliance and so on. So, Anastasia, these are cases that you've been working on. Could you walk us through a bit about what the doctrine means, how important it is, and what kind of achievements have been made recently in the courts?
Sure. Thanks, Tom. PLF has long had its eye on what's called Chevron deference, which is a doctrine that effectively requires judges to give away their power of judging to unelected bureaucrats in executive agencies. So this is a gross violation of the separation of powers, and it's really contributed to the uncontrolled growth of administrative agencies, which, as we like to say at PLF, they pass thousands of regulations each year, and they regulate everything from gas stoves down to Greek yogurts. These are unelected bureaucrats who are passing regulations that control, minutia of our lives. So what is Chevron deference? Well, it comes from a 1984 case that says where a statute is ambiguous, courts must defer to agencies' reasonable interpretations of that statute. So to put that into more concrete terms, that means that if you get caught in the crosshairs of some agency and you go to court because you don't think that the law applies to you or that Congress gave that agency the power to prosecute you, if the court finds the relevant statute ambiguous, it must then defer to the agency's interpretation of that law, even if it thinks that there's an objectively better interpretation of the law out there, even if your interpretation is objectively better. So as you said, Tom, it really puts a thumb on the scale in favor of the government agency in court. And in fact, it was a very powerful thumb because it turns out that the win rate for the government in court is significantly higher in cases where courts apply Chevron deference. So PLF has several cases representing individuals and small businesses who get caught up in regulatory nightmares. And then the agency then argues in court that Chevron applies and they win. And what's great is this past Supreme Court term, the court accepted a case to decide whether Chevron deference is valid. It was not a PLF case, but we did write an amicus brief, or what's called a friend of the court brief in the case, in support of the fishermen who were at the center of that case. The court accepts an exceedingly small amount of cases, in fact, fewer cases than ever in recent terms, somewhere around 3% of all cases that are petitioned. And so it's really remarkable to get a case granted, and it takes work by many liberty organizations to get there, many petitions. We have to keep knocking at the door, and eventually one will get there, and one did last term. And that case was called Loper Bright versus Raimundo. It was brought by a small group of fishermen. And again, I think just briefly describing the facts really brings this sort of abstract legal doctrine into perspective and shows you how these esoteric things really affect real world people. So I don't know how much you all know about fishing, but it's really hard work. The fishermen work under cramped conditions. They have already pretty small margins. And so the fishermen in this case were subject to a law that said that they had to carry federal monitors on board with them who would then look over their shoulder and watch for violations of the law. And that was one thing. But then the agency issued a regulation saying that the fishermen also had to pay the salary of those federal monitors. And at that point, the fishermen sued. And they said that the statute didn't authorize the agency to require them to pay. In fact, the relevant statute said that other types of boats had to pay the salaries, but didn't say anything about these Atlantic herring fishermen. And yet the agency went ahead and issued this regulation forcing them to pay. Now, the lower court in this case applied Chevron deference and therefore deferred to the agency and said that the agency was correct, that it could issue this regulation. But once this case got to the Supreme Court actually reversed, saying Chevron conflicts with the federal statute that requires courts to exercise their own independent judgment when interpreting law. So Chevron it's people who want to justify it say that these agencies are engaging in special expertise, which means that they should really be interpreting law, not courts. But as Chief Justice Roberts points out in his opinion, we're not talking about policymaking here. We're talking about interpreting law. And that is obviously a job that judges are better suited for than agency bureaucrats. So just one thing on this point is that you may have seen headlines saying that jettisoning Chevron is going to ruin the administrative state. It's going to bring down all these agencies and make it impossible to regulate wrongdoers, and that, pollution is going to run rampant and whatnot. And while I wish that Chevron was going to bring down the administrative state, it's not necessarily true, because all that this decision does is it makes Congress speak more clearly. Prior to this decision, Congress had an incentive to avoid making difficult decisions, right? It could pass ambiguous laws and then call up their friends in executive agencies and say, hey, you do the dirty work, you issue this regulation. And then the legislators would avoid the political accountability that comes with doing their job and passing clear laws. So this decision doesn't actually place any substantive limits on what Congress or even the agencies can do. It's not a substantive limit on these agencies. It's a procedural limit that puts the power back in the hands of Congress. Of course, Congress doesn't like this because it forces them now to do their job and to pass clear laws. It is going to place political accountability squarely back on Congress, and agencies don't like it either because it takes away their unilateral power to regulate our lives. But just to be clear and to sort of correct the headlines and the misinformation about this case, it doesn't actually limit Congress's ability to pass regulations. It doesn't limit agency power. It just forces Congress to be the ones to pass laws, and it evens the playing field for litigants against the government in court.
That's a wonderful explanation, because when you read the other side, quite often they conjure up a world in which there'll be no protection for anyone. The government will essentially cease to exist overnight. And this, as you point out, is a rule of law question. It's about balance of powers. It's not a substantive policy question about pollution or consumer protection or other important matters. Now, one thing I know about PLF is you're very thorough about following up to make sure that there's compliance with the laws. So what steps are you taking now in these cases to bring about proper compliance?
Yeah, we're no stranger to recalcitrant government. And so absolutely, we will be involved in enforcing Chevron. Even though the Supreme Court has said that Chevron is dead, we need to make sure that the lower courts apply that decision correctly. So we actually have 2 cases now that are on remand, given the Supreme Court's decision, to see how the lower courts apply this decision. And so I just want to briefly describe the facts of those. One is Foster versus U.S. Department of Agriculture. So this involves the Natural Resources Conservation Service, which basically declared a puddle that had come from melting snowdrifts as a wetland. And as anyone who has been involved in wetlands regulation knows, if you get some portion of your property declared a wetland, it triggers significant restrictions. And it means that the plaintiffs in this case are not allowed to farm that portion of their property, even after this puddle has dried out. So our clients had asked the NRCS to reconsider this wetlands designation. And the statute, we argue, actually requires them to reconsider the designation. But the agency refused. And so we sued to compel the agency to reconsider, but the lower courts had reflexively deferred to the agency under Chevron deference. Now we get to go back to court and say, hey, Chevron deference did not apply. You need to put our interpretation on equal footing with the government's interpretation, and we're going to make sure that the court does so. Similarly, we have another case, KC Transport versus Secretary of Labor. This is a case where the Federal Mine Safety and Health Administration had showed up at our company's facility and called them a mine, even though it's not a mine. It's merely a facility that has trucks there that are occasionally hired to haul coal. And so we had argued that this facility was not a mine, but ultimately, of course, the judge had deferred to the agency and said that this totally separate property that merely has trucks that sometimes deliver coal was a mine. And again, we're going to go back down to the court and say, hey, Chevron does not apply. You need to put our interpretation on an equal playing field. And, I'll note that Senator Warren actually has already introduced a bill that would require Chevron deference. So the Supreme Court, in its opinion, said, hey, Chevron's not authorized by any statute, so judges don't need to defer. And Senator Warren said, hey, this is the end of the administrative state. And, again, big businesses are going to have no accountability and pollution is going to run rampant. So let's pass Chevron deference by statute. Let's require it. But PLF has long argued that Chevron is actually unconstitutional because Congress can't delegate the judiciary's power to another branch. So if that statute were to pass, we are prepared to make such an argument in court and say that Chevron deference is actually unconstitutional and Congress cannot resurrect it by statute.
Well, one thing that I've noticed about your group is very tight legal organization, but also a tightly run ship as well. Make sure that all the things are done correctly in the right order and there's follow-up. And that's something that I would love to see in every country around the world. Groups like Pacific Legal Foundation operating to vindicate the rights of citizens. Atlas Network has that as part of our vision. We would love to see the PLF model replicated elsewhere. And each year, we organize a Smart Bets program, an accelerator program that chooses 10 of our capable partner groups to take part in a unique set of opportunities that are designed to help them to reach the next level of impact and efficiency. And one of those is our Smart Bets program, our Smart Bets virtual pitch competition in particular. Each of the 10 groups will make the case for why they should be among the 3 to advance to the final round, which will be a chance at the Big Liberty Forum and Freedom Dinner this November in New York to win up to an additional $50,000 investment in their project. So I'd like to invite everyone to sign up for this virtual pitch competition. It'll take place in the September issue of Freedom Worldwide. There's a link in the chat box, and you'll get to know some really awesome, amazing champions of liberty. So just click on that box and you'll be able to take part. I'd like to turn back to Stephen and just ask, what is it like to work with such a focused and outstanding team as the ones we've met today and the others who work with you?
Yeah, I'm a very fortunate guy. I've been able to work in the public interest legal movement for now 20 years. Actually, my 20-year anniversary is coming up in just a couple of days. First at the Institute for Justice, as you mentioned at the top, Tom, and then now at Pacific Legal Foundation. But my introduction to these ideas actually stretches back even further to a program, Tom, that you ran back in 1993 for Institute for Humane Studies. So I am living my dream job. There are very few places that you can work to literally change the trajectory of the country, and we're one of those places. And while the 3 of us get to be here at this webinar, we have nearly 150 employees at PLF, and we're litigating almost 200 cases around the country. So it's far more than just just us. And one of the things that I think makes the brand of work that we do a little bit different is it's not just filing lawsuits. It is really trying to affect legal change through our policy department, through our communications, scholarship departments. And I would remind people that legal change is the front end of cultural change. If you look at Brown versus Board of Education, that was 1954. It wasn't until 1964 that the Civil Rights Act was passed. So we believe we are at kind of the tip of the spear, but we want to bring the culture along with us. And it's a very exciting place to work. We've had great success, but we're focused squarely on the future, right? We don't rest on our laurels, but in the end, we do know that freedom is going to win.
One of the things that's so important is the focus that you put not just on the policy questions, but the law, that the rule of law is so central to a free society. And I think that is really outstanding, as so many other groups are just focused on this issue, this policy question. And you look at the framework of a rule of law and a liberal democracy by which decisions are made and accountability for governmental actions. So we have a question from Lee Benham. Lee says, as I understand, there are often high transactions costs to obtain some government records and data. What specific changes would you like to have implemented to lower your costs of obtaining government records and data? Who would like to take that on?
I guess I will. We did a lot of records requests around the country to figure out how many states were actually engaging in home equity theft and just how much money was at stake. And what we figured out, the short answer is more than $100 million per year was being lost from homeowners to the government or the government's cronies before we won Tyler. I think one of the main things is sometimes the local governments and will try to make it expensive to get your records requests fulfilled. They'll, I don't know, they're quite generous with themselves in some locations. So I think Florida has some good protections for that, where you can, if you're getting the runaround from local government, you can go file a suit and get your attorney fees paid. So I think for states that don't have that, I think that would help keep local governments honest.
Okay.
I might just add to that, Tom. One thing that I've noticed in litigation is that sometimes it's not even the monetary costs that makes it difficult. It's the unwillingness, the defiance, the recalcitrance of these bureaucrats to answer legitimate Public Records Act requests. I don't know how to change that necessarily. This culture of, these people who are in government feeling like they have to defend the government, that they're invested some way in not responding to our requests rather than representing we the people and us. They work for us, and so I'm reminded of PJ O'Rourke, who once said, like, I want government bureaucrats who hate their job, right? We want people there who they don't love it. They don't want to be there. They're not, we want people who are trying to do less, not more. And so I don't know how to change that culture exactly, but that's really a sort of unrecognized transactional cost. It's not just the monetary cost, but the fact that we have to just keep trying and sometimes even litigate these FOIA cases or Public Records Act cases just to get people to respond to us.
So it's sometimes an adversarial relationship, although I guess Christina pointed out there are occasions when people are quite forthcoming with the information that you need. I'd like to ask then a question that one of our participants raised about working with other groups. How do you divide up responsibilities, if you will, if you're working with Platt in Nebraska or Buckeye or Institute for Justice or another group? What's the way you decide on division of labor?
Well, I guess I'll say it depends. So a lot of what we do, we don't even have to reach that question because we're reaching out to them for coalition purposes. Look, you're the expert in your state, the state legislators. You tell us how we can come in and help. So like that's a really common way that we'll work with local groups where we say, look, you're the expert locally. How can we help get this done together? But as far as litigation goes, if we're representing our clients, obviously, you never, again, never have to reach the question of how do you divide the labor? Well, I'm representing my client zealously. And then you have these groups that come in and say, you know, we want to file an amicus brief supporting your client. What can we do to help? And so usually we don't really have an issue there.
Tom, I think one of the things to recognize, I mean, we deal with markets, right? That we're free market groups, and we recognize comparative advantage. You know, there are often issues that come to us, cases, and we say, you know what, this is not quite in our wheelhouse, but we do know of other groups that do this kind of thing. And I think that's the important thing to recognize, both in the kind of public interest legal world, but also the network more generally, is that we each have our own, we're all required, right? We're dealing with a very, just the Department of Justice's budget, for instance, is $1 billion. And that's just one government agency that we have to file lawsuits against. So it's all hands on deck, but each one of us has an important role to play through all the theories that we're engaging in.
Let me ask a question, Stephen. As a CEO, PLF has a long history, and in recent years, you've had just a string of successes. What are some of the other highlights in the history of the organization about property rights, which I know has been an important part of your work, as well as these procedural or balance of powers issues?
Yeah, thanks for asking that. Yeah, I mean, we had our first Supreme Court win back in 1987, and it had a nice 3-decade win streak until I came to PLF, and that was promptly lost. But we're back on track now, and have had now 10 wins since then. Our bread and butter for a long time has been property rights, both kind of on home equity, what Christina's mentioned, but also other parts of what are considered property rights on regulatory takings, for instance, the ability of government to kind of regulate your uses out of existence. We've also had some great wins on environmental law and really trying to decrease the power of government to kind of lord over our property. In fact, we had one set of clients who are in a very well, part of a club you don't want to be part of, and that's going to the Supreme Court 2 times. And now, thankfully for them, they've won both times. But it's been 17 years now that they've been trying to build this house in Priest Lake, Idaho, and still haven't done it because of what the EPA has asked for from them. So, you know, we've, as I've said before, we've had some really wonderful victories. We've had some good free speech victories as well. But right now, our focus is on expanding the property rights stuff, doing more work on separation of powers, ensuring that the branches of government are doing what the Constitution requires and no more, but also getting issues of equality before the Supreme Court as well, and particularly in light of the Harvard and UNC cases from a couple of years ago.
Well, I'd like to introduce a very important distinction. There's a reason why I've chosen to have this conversation with you and how important PLF is. And I'd like to announce that the Pacific Legal Foundation is the winner of Atlas Network's 2024 North America Liberty Award. Each year, we present this award to the organization that achieves the most innovative and impactful victories for freedom in North America, which is just the kind of outstanding work that you've been describing for us here today for our viewers. The award carries a $30,000 prize investment in support of Pacific Legal Foundation's mission, and it honors both your achievements, protecting property rights, protecting the rule of law, protecting limited government, and the separation and balances of powers, individual liberty that you've done before the Supreme Court and many other courts, and also the outstanding example that you set for pro-freedom organizations, not only in North America, but all around the world. And I'd like to really offer my hearty congratulations to the whole Pacific Legal Foundation team, your directors, your donors, your staff members, your lawyers, everybody, especially the 3 representatives we have here today. But we salute you. We think you're awesome, and we're so grateful for what you do for us. Stephen, would you like to tell us a little bit about receiving this award and what it means for you?
Yes, thank you very much to Atlas Network. We're both honored and humbled by this recognition. We understand there's lots of competition for awards like this, and I liken it to this is the Freedom Movement's Oscars, and to be recognized in this way is just an awesome, awesome thing, given the great work we know that all of the Atlas partners are also doing. And as I said before, it's the three of us here, but there are lots of people that are behind the work that we do, and I salute them as well. And it doesn't just come with a monetary prize, that which is wonderful. It also comes with this 30-pound glass recognition, which will be going in our DC office when I go there in a couple of weeks. So thank you so much for this honor.
Well, it's an important part of Atlas Network's work that we believe in recognition of excellence, and it helps to set a baseline for all of our partners around the world to strive to be able to always do better by having a baseline, seeing what other partners are doing, saying we can do that too, and then also being recognized for excellence. And you folks really have done an amazing, excellent job. And I can say, as a taxpayer and a US citizen, I'm very grateful to you for working so hard to vindicate my civil rights. Well, I'd like to thank everyone for participating, and thanks to all the financial sponsors of Atlas Network who make this possible. We're deeply grateful to you. We respect you, and we work every day to make sure that your investments go to the highest value, the highest return on investment to secure individual liberty and limited government. Now, if you're moved, as I am, by what you heard today, a great step to take would be to come up and meet our partners in person, to join us in New York City on November 20 and 21 for the Liberty Forum and Freedom Dinner. It will be held at the Sheraton Times Square. It's a premier 2-day gathering. It's going to be your chance to get to know many of the world's most awesome, brave, courageous, far-sighted people who are advancing individual liberty, freeing markets, limiting government power, and securing the right to everyone to enjoy the blessings of liberty, the prosperity and peace and progress that they make possible. Come and join this and celebrate with us at the awesome Freedom Dinner Gala. You'll also be there when we announce the winner of the prestigious 2024 Templeton Freedom Award, which honors the organization that has accomplished the most innovative and impactful victory for individual rights and economic empowerment around the whole globe. It's an opportunity you won't want to miss, but if you act now, you'll even receive our early bird discount of 25% off the cost of your ticket. So just go to atlasnetwork.org/events today for more details. And there we finish this up. Thank you so much for joining us. Thanks to our PLF participants. And we look forward to more and more victories in future. Thanks much.